What's up, everybody? I am MIMS. We're going to be doing some MIMS morning news today. Welcome in, welcome in. So, TikTok, we're going to be going mute here. So, please go here to makeit.makesense.america at YouTube. That's where I am. Much love, y'all. Go follow me there. Reported? Why reported? Reported for what? Well, I muted TikTok. Reported for what, you stupid motherfucker? What? What have I said that would cause you to report me? Seriously, what have I said that would cause you to report me? You silly little bastard. You don't even understand. Dumbass. You're a dumbass. That's what you are. You're a dumbass. Jesus. What up, John? What's up, Cat? Fairy in the chat. What's going on? What's going on? How are you, Tanya? Good to see you. Good to see you. Silly little bastards in TikTok. Can you imagine? Jesus Christ. I like being able to call them silly little bastards here. Kind of feels good for the soul. Silly little bastard. What's going on, folks? Welcome in, welcome in, welcome in. All right, so we're going to talk about just the news that we have going on. Supreme Court's hearing January 6th obstruction case. Got some live updates on that. Let's see. Fucking paywalls. Lame. Lame. All right, let's shift gears and go to the news. That's not the news. That's the news. Okay. Good morning, everybody. Siege. What's going on, Siege? Spire collapses after a fire rips through Copenhagen's old stock exchange. Really? Huge fire engulfed Copenhagen's old stock exchange, one of Danish capital's most famous landmarks, causing its spire to collapse, and staff and citizens scrambled to rescue paintings and historic artifacts from the blaze. Cannot describe how upset I and my colleagues are. Wow, 400 years of cultural history that went up in flames. Sad. Is there a video? Wow, that is sad. Wow. Wow. We wouldn't need to mute your account if you weren't spreading misinformation, just saying. Whiskey! What misinformation am I spreading? Oh, wait. You're muted. What misinformation am I spreading? You silly little fucker. What misinformation am I spreading? You silly bastard. Can you imagine? Yeah. All right, NPR editor is suspended after an essay criticizing the network. Interesting. Interesting.
As you know, my son is graduating from high school, and it looks like the judge will not let me go to the graduation of my son, who's worked very, very hard, and he's a great student. So proud of the fact that he did so well. I was looking forward for years to have graduation with his mother and father there, and it looks like the judge isn't going to allow me to escape this scam. It's a scam trial. Next Thursday, we're before the United States Supreme Court on a very big hearing on immunity. And this is something that we've been waiting for a long time. And the judge, of course, is not going to allow us. He's a very conflicted judge. And he's not going to allow us to go to that. He won't allow me to leave here for a half a day, go to D.C. and go before the United States Supreme Court because he thinks he's superior, I guess, to the Supreme Court. We got a real problem with this judge. We have a real problem with a lot of things having to do with this trial, including the DA.
Me too, John.
You go right outside and people are being mugged and killed all day long, and he's sitting here all day with about 10 or 12 prosecutors over nothing.
He looks like he's tired of winning.
So I just want to thank you very much. But that I can't go to my son's graduation, or that I can't go to the United States Supreme Court, that I'm not in Georgia or Florida or North Carolina campaigning like I should be.
It's goddamn right. Stay out of North Carolina, Trump.
That's exactly what they want.
North Carolinians don't want you here, Donald Trump. At least in my opinion, we don't.
Pay a lawyer and mark it down as a legal expense. Some accountant, I didn't know, marked it down as a legal expense. That's exactly what it was. And you've been indicted over that. I should be right now in Pennsylvania, in Florida, in many other states, North Carolina.
No.
This is all coming from the Biden White House because the guy can't put two sentences together.
This is all coming from the Biden White House?
They're using this in order to try and win an election, and it's not working that way. It's working the opposite way.
Yeah, he really fell asleep in court, didn't he?
It's called legally.
Crazy.
That's what you're supposed to call it.
Crazy, man. Donald Trump is learning the hard lesson. Criminals, defendants don't get to set their own schedules. 3 times on Monday, the former president asked Justice Juan Merchan to cut him loose from his hush money trial to attend to other matters. Some personal, some political, some legal, and 3 times the judge responded with, we'll see. Could he attend his son Barron's high school graduation May 17th? I'll get back to you, Merchant said. May he skip trial August 25th to attend to Supreme Court arguments about whether he's immune from special counsel Jack Smith's charges for trying to subvert the 2020 election? Not likely. God. It's just the worst, man. Looks like the judge will not allow me escape from this scam. Scam or criminal trial, bitch? Jesus. Play stupid games. Win stupid prizes. Yeah, fuck around, find out. You're goddamn right. What's up, Marley? How are you? Get him, John. People are like, you're muted. I'm like, read the fucking screen. You're muted. Yeah, no shit. I know. Read the screen. Okay. Well, since you had my first error on my printer. And then I had my first filament clog. But I got it. So we're good. Oh, good news. That's good. That's good. If you're innocent, you wouldn't have to do any of the crap Trump's trying to do. Delays, begging for immunity. You're right. You're right. You're absolutely right. You're absolutely right. If you're innocent, you wouldn't be doing all this shit. This line in Fallout Episode 2 is haunting you. Have y'all seen Fallout? That show is great. Potentially... yeah, mm-hmm. Yeah, yikes. Yeah, the new Fallout's great. Let's see. Yep, I'm muted. Go follow me on YouTube. I'm not muted there. Adobe's new generative AI tools for videos are absolutely terrifying. Wait a damn minute.
Pro.
Skip.
Transform how editors work.
Sorry, I want to watch this real quick.
One editing challenge is finding something in a shot you need to add or replace. The Object Edition feature in Premiere Pro, combined with Adobe's Firefly video model, lets you add or change objects in footage with a text prompt. Make a selection, write a prompt, and add anything you can imagine. These diamonds were created with the Firefly video model currently in development.
My God.
Not only can you add objects, but
Do you see that?
remove them too. Object removal with AI-based smart masking makes selecting and removing objects across frames quick and precise. Here, this
No way.
with Firefly.
Dang.
Props, crew or gear, or copyrighted elements like brand logos. So, all your edits are
Dude, that's crazy.
When your clip is too short and you want to hold on a shot or a character for an extra beat, Generative Extend intelligently adds frames with Firefly, extending your footage, so you have the exact media you need. Like here, where we extend this shot of the woman a few frames. As we continue to innovate, we're committed to transparency through the use of
Dude,
content credentials.
what?
Now coming to Premiere Pro, so you always know whether AI was used in the creation of the media you're viewing. We can't wait to bring these Firefly-powered video editing workflows to Premiere Pro later this
That's
year.
fucking wild.
There's more.
Wild.
We're excited to share our explorations around giving editors the choice to use models that work best with their footage. Here are some early examples
Wow,
of
that's
how
good, Marley.
generative AI models could look within Premiere Pro, like Pika, powering Generative Extend to make a scene flow better.
That's crazy.
From OpenAI, here's an example of their Sora model, currently in early research, generating B-roll for any scene. Through simple text prompts, Sora creates variations for you to choose from.
Yo, that's fucking
The same use
crazy.
case now using Runway AI's video model, generating a new video clip and adding it to the timeline in a snap. And content credentials coming to Premiere Pro this
What?
year will always make transparent whether AI was used and what model was used in the creation of media.
Awesome.
To recap, revolutionary features like
That's
object
fucking
add,
wild. I don't know if y'all
remove,
tracked that.
extend, powered
That
by the
shit
new
is
Adobe Firefly
crazy.
Video model are coming to Premiere Pro. And we're excited to show early research explorations with our friends at OpenAI, Runway, and Pika, so editors have the freedom to use the best model for their project.
Yo, and I have this.
It's Adobe
I'm
Premiere Pro,
excited.
supercharged
I'm very excited.
by AI.
That is very cool. Very, very, very cool. And scary. And cool. And scary. And cool. But scary. Obstruction case. Ah, you silly little...
Me, what you feel about the Walker view, Judge Walker being part of the majority. I assume you know that, but
Yes, so Judge Walker articulated an idea that corruptly has to turn exclusively on the government being able to show that the defendant sought to
All right, we're gonna put that over there.
advantage for himself or someone else. We certainly agree that that's one way for the government to prove corrupt intent. It's a way that has traditionally been deployed in the tax context because the very theory of the case is that the defendant is violating the tax laws or taking efforts to secure an unlawful advantage under the tax laws. But I think that it would be incorrect for the court to suggest that that's the exclusive mechanism for the government to try to prove corruptly. You know, there are various other ways where we might have evidence of, as we think we do here, unlawful means committed with consciousness of wrongdoing, and there's no basis in the common law or
Isn't that wild?
the term corruptly has long been understood to limit the government's ability to prove it only with that one specific way that Judge Walker pointed
the
to.
juror in this case appears to be the fear that reading the government's view of either yesterday's case or today on its plain terms would make it so broad that somehow that presents a problem. I think the judges below struggled with that by saying that gets addressed in the word corruptly and in the nexus requirement, which is the point you made today. But neither of those two issues were resolved below because that wasn't the question below.
God, Israel, what are you
That's right.
fucking
The only
doing?
issue that the D.C. Circuit resolved was the meaning of the actus reus.
And the only issue between us is whether we read the words, how we read these words.
That's right, but I don't want to lose sight of the fact, as your question touched on, that there are inherent constraints built into the other elements of the statute. The nexus constraint
let's
is a really
see.
critical one. It is the paradigmatic constraint the court has pointed to ensure that obstruction statutes don't sweep too broadly and scoop up everyday conduct that might be happening out in the world. It has to
Wooden
have
edged
tight
phones?
connections, a relationship
Motorola?
between causation or logic with the official proceeding.
Wooden
And
phones?
of course, corruptly, we think, sets a very high bar, as evidenced by the fact, as I said to Justice Kagan, it's not like we can even prove it with respect to everyone who was
Yeah.
in the riot at the Capitol on January 6th.
Thank you.
General, are you putting a violence requirement as an overlay on obstruct, influence, impede? And I'm thinking of some of your answers to Justice Alito's hypotheticals. It seemed like you kept emphasizing the aspect of violence that was present on January 6th. So am I understanding you to say there has to be some sort of violence or no?
No, we don't think that's a requirement under the statute. I think it will clearly be easier for us to satisfy things like the corruptly mens rea when we can point to action here, like assaulting a police officer that is obviously wrongful, unlawful conduct, and everyone knows that that's a crime and you cannot do that. What I was trying to say to Justice Alito is in situations where hypotheticals press on the idea that people are engaging in conduct that maybe they think is constitutionally protected, they might be wrong about that. There might not be a First Amendment right that they think they have, but that can demonstrate that they don't have the requisite consciousness of wrongdoing that would mean we couldn't prove an obstruction charge.
Thank you, counsel. I'm not quite sure I understood the answer you gave earlier about whether or not you've previously used C2 in this type of case. Have you done that before or not?
We have charged C2 in situations that don't involve evidence impairment, and the litigating position of the department has long been that, as its plain language suggests, it covers myriad ways of obstructing. I'm not aware of any other factual circumstance or event out in the world where we could have proved all of the elements of Section 1512 C2 beyond the cases where we've brought those prosecutions. So,
Just so I understand, the prosecutions are limited in what way?
they're limited to a requirement that the specific people had in mind an official proceeding. So that would take out the category of hypotheticals where, you know, maybe you're protesting a branch of government, you're outside this court, but you don't have this specific argument in mind. And then we would also need to show an intent to obstruct the proceeding and the nexus to the proceeding, and that can take care of, you know, situations where maybe someone's
That's cool.
fire alarm in a different
I'm gonna try this one.
not even where the proceeding happens.
In prior cases, you have applied C2 in a situation, not involving specific...
So this is the one I'm going to be doing
Correct.
here.
So things like tipping off someone to the existence of a grand jury investigation, or the identity of an undercover officer, or creating a fake court order that has nothing to do with the evidence in the case, but is just prompting the litigant to dismiss a pending mandamus petition.
And your friend's
Bamboo
friend
Studio.
points to a Office of Legal Counsel opinion
Won't let me snap it to that window.
I haven't looked at it yet, but I will. It says
But
it is,
why not?
consistent with Judge Kansas's opinion below.
So that advice that was offered to the Attorney General and never adopted as a formal position of the Department of Justice related to distinct issues that arose out of the special counsel
I wonder why.
investigation and distinct issues that involved the office of the presidency. I don't think that it would be right to suggest that the memo took any firm stand, although it did suggest that maybe 1512C2 should be understood more narrowly, but it certainly didn't represent any formal adoption of that position, and that would have been inconsistent with how the government has always litigated under C2.
What constitutes a formal acceptance of OLC opinions?
I should probably know the answer to that one as a
I
matter
should
of
too.
DOJ policy, but what I can tell you is the reason I'm saying that wasn't an official position is because it specifically said there's no need to go down the road of even deciding exactly what 1512C2 covers, because even assuming that it covers the full range of obstructive conduct, the allegations, according to the memo, didn't satisfy.
These are all 3D prints.
So it ultimately just punted on the issue and said it's not necessary to engage with that issue.
How cute is that?
Thank you, Justice Thomas.
General, you said, as I understand it, that you have applied C2 in previous cases.
That's
Came
right.
straight off the print like
Cases
that.
Do not fit the evidence impairment model that petitioner is urging on the court here. And it's not just C2, Justice Thomas, but it's the omnibus clauses of 1503, 1505,
Anti-fascist
1512.
action.
You know, these are statutes that use the exact same verb
Those are
phrase.
fine, but C2,
Yes.
I'm not clear as to whether or not these specific instances in which you have used C2. Because you seem to think that argue that C2 is a standalone provision almost.
We think that it covers the full range of obstructive conduct that's not covered by C1, of course limited by the requirement of an official proceeding.
So if you have applied C2, have there been previous, other than the D.C. Circuit, previous courts of appeals that looked at this?
Yes, and the uniform consensus among the Court of Appeals has been that C2 is not limited by this kind of evidence impairment gloss that petitioner is asking the court to read into the statute. There has been no Court of Appeals that's gone the other way. We cite a string side of them that have recognized, looking at the plain language of this provision, that it sweeps in the myriad forms of obstructive conduct.
So much of your argument seems to hinge on this being fairly clear, your interpretation of C2.
Yes, we certainly think we have the best of the plain text.
Okay, if I happen to think it's more ambiguous, what would your argument be?
So what I would say is I think that if you look at the terms in the statute themselves, that the plain language of the statute supports our view, but it doesn't end there. And I have mentioned several times the other provisions in 1503, 1505, but we think that's actually really relevant because Congress wasn't writing on a blank slate when it enacted 1512C2. It's not like it just thought of for the first time this word phrase.
These are all free files here
That wasn't taken out of the ether. That was a well-established term
that you can
word
print
phrase in
out.
action law drawn from those other statutes. And as this court has said many times, when Congress takes a phrase like that, it brings the old soil with it. And so Congress would have clearly known that the courts, this court, and lower courts...
Picture me with this. What's up, friend? Hello.
...to encompass the full range of obstructive conduct. That's also consistent with all precedent, as I mentioned to you earlier. So I think when you put it all together, there's no real ambiguity here.
So let's see.
And the only other thing, the icing on the cake, if I could, is that if actually what Congress wanted to do is write a statute that focused only on evidence impairment, there was a really clear and obvious way to do it. Congress could have just tacked on a residual clause to C1 that says, or otherwise impairs evidence. It would not have used this oblique reference of otherwise and then used a term that had a well-settled meaning in obstruction law to sweep more broadly to try to convey that type of limited scope. It would just be nonsensical for Congress to draft that way because it would be so readily misunderstood. And in fact, every lower court has understood Congress to have legislated more broadly here.
Well, that's beginning to sound more like a contextual argument, which you seem to eschew in this case.
Well, no, I think actually that the statutory context and history does bear weight here, and we think that the roots of this language and those other obstruction provisions help fortify or reinforce how the court has always understood the plain language.
Justice Alito?
You argue that there's an exception for conduct that has only a minimal effect on official proceedings. Where does that come from in the text?
That comes from the verb phrase obstruct, influence, or impede, which we think, if you look at dictionary definitions, conveys the type of action that blocks.
Hour and 20
hinders,
minutes.
makes difficult,
Wow, that's not bad.
persistently interferes with.
Hey, Christy.
This is the kind of the verbs themselves we think inherently
Okay.
contain this limitation.
There can't be a minor impediment?
I think as a colloquial matter, yes, maybe, but we think that if you look at what Congress was trying to do as a whole, the lead term here is obstruct. These were various ways of trying to capture the world of obstructive conduct, and I think that adequately conveys the idea that some kind of very minimal.
Yeah, good luck convincing everyone to leave TikTok,
Well,
though.
it didn't stop with obstruct. It added impede. But what is the meaning of, how would you define a minimal interference? I suppose a jury would have to be charged in order to person violated this provision. You must find that the person committed more and caused or intended to cause more than a minimal interference. How would you define it?
So I think
Yeah,
to the
it's
extent that
better,
this would
okay.
come up in actual prosecutions, and I'm not aware of any.
Let's
but if
make
came up,
this,
then I think that it would be the defense theory. It's possible that the court could decide it as a matter of law. If
Black
in
would be
fact it's
okay.
so minimal, it doesn't fit within the statutory terms themselves. And I recognize that maybe there could be gray areas about the nature of the obstruction and whether it really satisfies the actus reus. I think that is properly.
What about the example I gave you about the 5 protesters in the courtroom? Is that minimal?
I think that sounds minimal to me. I mean, it sounds to me like if it hasn't actually forced any substantial halt to these
Yeah,
proceedings,
picture me
it
this.
seems like that
I
would
agree.
Pick up and track, but
I agree.
the same issue would arise under 1503, which likewise refers to obstruct, influence, or impede.
You haven't said anything about the surplusage arguments. Let me just-
No, and the reason that'll get banned because they're making TikTok money.
Suppose someone commits conduct that falls squarely.
I don't do battles.
15
I don't make TikTok money.
intentional
I don't want to beg y'all
person,
to
and
spend your money for me, with me, at me.
testifying in
TikTok needs it, so they push it.
square,
So
clear violation 1512D, punishable by no more than 3 years in prison. But when Congress added 1512C2, which seems to cover exactly that conduct, it said, well, the punishment shouldn't be, you could punish that person for up to 20 years.
There's a key difference between 1512D and 1512C in that D doesn't require the intent to obstruct. And so the effect of the defendant's harassment action is to prevent the testimony or the production of the document, but the government has not read that statute to require an actual intent to obstruct, which I think means there are certain factual scenarios where the government might be able to prove a 1512D offense without satisfying C2. But I do want to be responsive to the broader concern that there's something anomalous about the 20-year penalty here. Let me say at the outset that no matter which statute the government charges under, with respect to all of the relevant obstruction statutes here, they would be funneled through the same sentencing guideline. So the charging decision wouldn't make a difference with respect to the sentencing range. And the concern you have with the hypothetical arises equally on petitioner's reading, because so too, everything that would be covered in 1512D falls within his evidence impairment limitation. So I don't think the existence of a statutory max when there's no mandatory minimum should drive intuitions about how to interpret this provision.
Well, I'm not sure that's the correct interpretation of subsection D. How about
yeah, I don't know.
1512D,
Picture me this. I don't know.
which also has a 20-year penalty, but it seems to be completely subsumed by C2.
I think there is a lot of overlap between B and C. I don't deny that. Again, that would be true on either reading because B is paradigmatic witness tampering. And so even on petitioner's understanding of the statute, there would be equal duplication there. What I would say is there's no actual superfluity because there are ways of violating B that wouldn't fall within our understanding of C2, including acting in a misleading manner towards someone, which wouldn't necessarily satisfy a corrupt intent.
God, it's taking
definition.
forever. Jesus.
Really, you think you could knowingly threaten or corruptly persuade, corruptly mislead someone? I don't understand that.
So my recollection is that there are multiple different means of carrying out that offense. Of course, something like threatening or corruptly persuading, that's the kind of duplication I was referring to earlier. But another way you can violate B is through intentionally misleading someone. That wouldn't necessarily require corrupt intent.
Okay, thank you. Sorry, one more question. I was struck by the contrast between your argument here.
I'm so tired of listening to these old folks.
In a minimal exception with the argument that you made earlier this term in Muldrow versus the city of St. Louis, where the question was whether an adverse employment action has to be significant or not. And you said, no, it doesn't have to be significant because, quote, the text likewise admits of no distinction between discrimination that results in a significant or insignificant disadvantage. So in Muldrow, you told us, no, don't read in an atextual requirement of significance, but here you seem to be arguing, yes, you've got to read in an atextual requirement of something that's more than minimal.
No, that is not our argument here. We are grounding this in the text. So we're not suggesting that there's a basic de minimis principle that applies throughout all the various legal statutes that are out there. Not anything like that. Instead, we ground this in a particular understanding of what it means to obstruct and what that word conveys.
Thank you.
Justice Sotomayor? I know the Reese case because I decided it.
Printer's back.
However, the chip cases, are they in your brief?
It's funny how much you can learn about your 3D printer just by the pieces that come off of its normal, everyday maintenance. You can actually tell a lot by your printer's poop as well. It's going to sound crazy, but yeah. 3D printers purge. This is the normal style. Last night, mine apparently had the squirts. It came out this way. And that's not okay. And I was like, what in the hell is happening? So, another good example. That looks weird. That doesn't look normal for my printer. This is another one that was some of the printer poop. See how that just looks weird? All the rest has these little cone, those little conical things. But not that. Not that. So, pay attention to what your printer goes through, and yeah, look at this one. That, to me, made me learn that there's a clog. And then this is one of the towers. This is how the tower is supposed to look. So you can't see through it. And this is how it came out when there was a clog. And I was like, holy hell, something's wrong.
So I don't think the idea that 1519 was the broad catch-all can in any way be squared with what that statute says or how this court interpreted it in Yates. And instead, I think that the example to draw from Yates or the lesson to learn from it is that this court recognized that Congress was plugging the specific hole in the Enron scandal, and it did so with overlapping provisions, 1512C1 and
partial clog. Oh, yeah.
1512 that the court pointed to as the place where you would sensibly locate this broader provision that aims at the
oh God, it took 24 hours.
The known unknowns.
You're busy as fuck, I hear you. Yours should be just a threaded nib that you can just pop off. An expensive dust collector. These Bamboo Lab ones are fast, cheap, and relatively mess-free.
Limit those clauses beyond their plain terms, even though these kinds of provisions have been in the election law. I think it traces all the way back to 1830, and they've never been understood to have that kind of narrow limitation to evidence impairment or anything else.
Thank you. Justice Kavanaugh?
The key word in the
I'm not able to see this
I'm trying to figure
printer.
out what that means
Here,
under our
doink.
established principles of statutory interpretation. It would seem to trigger
Will it load?
some generous
Maybe you'll will be able to see me.
precedent.
Whoa.
You've used the phrase a few times, catch-all
Undo.
provision, as does your
Well, you'll be able to watch it, but it's a little messy.
Our book describes justum generis as how you interpret catch-all provisions. Does justum generis apply here or not?
No, we don't think it can sensibly apply here. So the court has said many times that otherwise is a natural way for Congress to create a broad catch-all category. And I certainly don't dispute that there can be situations where you have a parallel list of nouns or a parallel list of verbs where the court might further think that used and generous principles apply. But that's just not how 1512C is structured. It has, as I've mentioned, its own complex internal structure. You've got the mens rea requirement that's unique to C1, and Congress did not transplant that into C2. That triggers the other canon that when Congress uses disparate language in two adjacent provisions, usually it means something by that. So I think that this just isn't the kind of situation where the court...
Idaho Snowflake in the house. What up, friend? Welcome, welcome.
If the court goes down the road of trying to glean some kind of requirement from C1, the other reason the canon is inapplicable here is that it's not evident on its face what the common attribute would be, and that relates to the Nichols taxes dispute.
As you know, that's true in almost every justum generis case, and the treatise explains that as well, which is it's hard sometimes to figure out what the common link among the words in the phrase is. So that's, I don't think that point I don't think distinguishes this case from other justum generis cases, but you can respond to that.
But I do think that a plain speaker of English would recognize that usually the common link or the connective tissue is the language that follows the word otherwise. That's the congressionally approved similarity. That's what C1 and C2 have in common. They both
agree.
to obstructing an official proceeding. And, I recognize the petitioner has invoked Begay. Your question touched on it. But the statute in Begay, which we think is not the model of statutory interpretation...
That's cool. Look at those keycaps.
The statute itself was relevantly different. It had a list of...
Fucking
nouns,
cute.
So it was the kind of statute where potentially a use in general
Annie.
would apply.
Doink.
What about the contextual points? A couple of them that I think have come up, but I just want to make sure you have a chance to respond. That it would be odd to have such a broad provision tucked in and connected by the word otherwise.
I don't think that the placement in the statute is odd at all for a couple of different reasons. One is the point I was trying to make to Justice Kagan about this court's own recognition that 1512 is one of the big obstruction statutes. This is the statute that is aimed generally at official proceedings. It's not more discrete, and there are other provisions like 1519 and some of the ones that come right before it that are more narrowly confined and are intended to reflect discrete circumstances. That doesn't
How
apply to
freaking
1512
cute.
at all. So when Congress was trying to broadly prohibit obstruction of official proceedings, 1512 was exactly the right place to go. Then petitioner says, well, Congress buried it in the middle of...
How fucking cute is that?
I think it's actually...
I kinda need it.
When you look at how the other provisions are structured. 1512D, which I was discussing...
I need to
with
swap out
has a much more minimal penalty and
some of my
doesn't require
filaments.
intent to
How long is
obstruct.
this going to
So
take?
it made sense to put 1512C before it, but also after 1512A, which is the most serious obstruction, like killing a witness.
How long do you think this will take to print? Anyone?
Last question. There's 6 other counts in the indictment here, which include civil disorder, physical contact with the victim, assault.
Yo, Mike! We're on YouTube! Come over to YouTube. I'm silent here today. Much love.
Disorderly conduct in the Capitol building.
This little fucking thing is so cute. So cute.
Good enough, just from the Justice Department's perspective, given that they don't have any of the hurdles.
I wonder if I end up... So with this slicer too, you can take this fill and you can do a full fill. Let's do a different color that we don't have picked yet. So you can change this whole thing to yellow. Look at that. So if you have a filament up here that you don't have, like I don't have those filaments in here, so I'm going to sync it. So this is synchronized here. So if I want to just have the eyes be black filament, I could do that, and it'll just change it to black. I mean, hell, if you wanted to have his name, let's see if it'll do it. Oh, it won't do it. I have to shrink it down a bit.
impede the
So you can
ability of
highlight
officers to
certain
manipulate the
things,
flow of the Capitol and let
and
Congress finish
this way,
discussing that
their
session.
name will be
It is
highlighted now.
entirely appropriate for the government
Isn't that
to
cool?
seek to hold petitioner accountable for that conduct with that intent.
But I don't know that person, so I'm not highlighting their name.
The sentence available is longer.
But this will end up being
Statutory maximum is
green, I guess.
after a recent decision in the D.C. Circuit, which held that a particular sentencing enhancement doesn't apply, that was the Brock case. I believe the sentencing range, the guidelines range for the assault count, would actually be a higher guidelines range. And just to give you a sense, for a typical January 6th
Whoa.
defendant, someone who doesn't have a prior criminal
Okay.
history and who committed violent
So that'll be
conduct,
green.
accepting responsibility, I think the average guidelines range, or the range that would yield, is 10 to 16 months of imprisonment. For someone who didn't commit violence, it would be 6 to 12 months of imprisonment. We've looked at the average sentences here. There are about 50 that have gone to
Let's see, hold on, I gotta collect.
sentencing on just a 1512C2 is the only felony, so I think that's the best way to
I
gauge
gotta make it all.
This is when the sentencing enhancement
hold
did
on.
apply, so the ranges were higher.
Hang
The
on, hang
average
on.
sentence among the approximately 50 people is 26 months of imprisonment, and the median has been 24 months. So there's no reasonable argument to be made that the statutory maximum here is driving anything with respect to sentencing.
Thank you.
Mrs. Barrett?
General, I want to ask a clarifying question about the distinction in the government's charging decisions between C1 and C2. Actually, let me make that stronger, not charging decisions, like what you could charge under the statute. So as you pointed out to Justice Kavanaugh just now, C1 has this additional mens rea requirement, but there is
See how that's
overlap if you read otherwise
showing up here?
influences.
A little wonky.
Broadly, it would
So it's red.
encompass, frankly, even in the other reading, it would encompass things like alters, destroys, mutilates, etc. But you wouldn't have to prove the extra mens rea. I thought I heard you say, and I just want to clarify to Justice Jackson earlier in the argument, that the government could not charge an
Let's see.
alteration,
See how there's red,
mutilation,
little red dots?
a document or physical object under C2, right?
That's correct. We usually charge the specific paragraph.
Let's see,
and
how
so
would I
if
best
it's
go
within
about doing
C1, we
this?
would charge it under C1, and that would be the proper
Okay,
place
if
to
we
locate the
convert
charges.
everything into
Control discretion, or do you think the statute would permit you to
a
charge
solid
under
color
C2
here.
escaping the specific intent requirement?
Well, let me say that there is a specific intent requirement under C2, so there's no distinction
But it's
between
different.
right? It's the intent to obstruct the official proceeding. So you're right that we wouldn't have to prove intent.
Okay,
to-
the whole pumpkin is
We would still have to show the intent to obstruct the proceeding.
gonna be
And this is
orange.
pressing on, honestly, what's a difficult
And the
question because
eyes,
there's elements,
the nose, and the mouth.
I think the best reading of the statute is that these are different elements because they have these different actus rei, they have the different mens rea the mens rea requirement that's specific to C1. They each independently prohibit attempts, but it's a hard question ultimately. And if we charge under the wrong paragraph accidentally, I think we could usually say that was harmless error or else recharge under the correct paragraph.
Okay, let me ask you a question that kind of gets at some of the same points that Justice Alito's questions were getting at. So, what if on January 6th, the Capitol itself had not been breached, the protest is going on outside the Capitol, stop the steal, police are, in megaphones saying disperse, they're too close to the Capitol, their goal is to impede, stop the proceeding, stop the counting of votes. Does that violate the statute in your view under this impede language?
So I think that one relevant question would be whether we could satisfy the nexus requirement and show that actually the natural and probable effect of that conduct would be to have some effect on what's going on in the Capitol and in the mind right.
You can.
Yes, so if you're assuming that the same thing happened where Congress had to go into recess and couldn't hold the joint session after all because there was such a security risk, I think that probably would be chargeable if we had the intent evidence. Now, as I mentioned before, even with respect to the riot that happened, which was a much more serious breach, we don't have that evidence of intent for everyone. But if we have, for example, organized...
So we can go through and we can adjust that too. And then once we swap filament, then we'll just ensure that number 1 on my spool here stays black. Number 2 here, which is gold, will get switched to orange. 3 is unassigned, and then 4 would have to be like a brown or a green or something. So yeah.
Impedes to have this extra element. Tell me why I shouldn't be concerned about the breadth of the government's reading, just relying on corruptly and...
It's right here.
Should I be concerned, or should you just embrace it?
It's right here, Mike.
There might be some as applied.
much love, so much love. Thank you, thank you, thank you.
Can I be comfortable with the breadth if that's what I think?
Yes, you can be. You certainly don't have to agree with us that a de minimis hindrance wouldn't qualify. If you thought that this was unqualified and swept broadly to any kind of hindrance whatsoever, there would still be really important limits in the statute. Obviously, you have to have the official proceeding. I think the nexus requirement could be somewhat harder to establish in a circumstance where you might not think that the natural and possible effect of the conduct is going to be to obstruct the proceeding. You'd have to show that the defendant knew that the natural and probable effect would do that. You'd still have to show the corruptly mens rea. And as you mentioned, even if you could show all of that, if it were a
Hey!
that really did...
Oh shit, there comes trouble. What up, Mike?
Do you think it's plausible that Congress would have written the statute that broadly? I mean, let's say that I think that Justice Alito's example of the protesters in the courtroom, let's say it's correct.
Now I gotta follow you, Mike.
Because we have to go off the bench and things are stopped.
There's such a big delay.
Covered by the word impede, and there's the nexus of
There's such a big delay.
is it plausible?
Subscribed.
Sweep that in?
What up,
I
Mike?
think that there are a lot of legitimate ways to try to voice your dissent if you disagree with what the court is doing, but one of the ways you cannot do it is come into this courtroom, halt the proceedings, force the justices to leave the bench, and do it with the intent and the corrupt mens rea. I think that Congress could think that is a severe intrusion on the functioning of our government and want to protect against that. And again, the 20-year statutory max, of course, is just a max. There's no mandatory minimum.
All right, I'm gonna restart TikTok. Whoa. That was weird.
Thank you.
Justice Jackson?
So you've emphasized,
What? How did that?
times that Congress wasn't writing on a blank slate in 1612C.
Well, my century plant that I've had for decades,
And
it's bigger than my CRV.
Against the backdrop of a real-world context. It was in the
So
wake
that
of
means
Enron, there was
after she
document
blows,
destruction.
this one's going to the
And, there was nothing, as far as I can tell, in the enactment history, as it was
sad about it,
reported, that suggests that Congress was thinking
Had it for a
about
long time, but it's
destruction
all
more
good though.
generally.
It's okay.
It
She'll be
had
here
this
for a little while
particular
longer again.
problem, and it was destruction of
Well, my century plant that I've
information that could have otherwise been used in an official proceeding. So can you just give us a little bit more as to why we shouldn't think of this as being a narrower set of circumstances to which this text relates? Sure, and I'd start by saying that we of course acknowledge that the immediate impetus for adding 1512 to the statute was to close the Enron loophole. It was a glaring loophole.
Oh, closing the Enron loophole.
It wasn't a crime for you personally to destroy the document, and the government had to charge people for instead persuading other people to destroy documents. So that was front of mind for Congress, and Congress wanted to address it. It did address it with C1 and with 1519 separately. But I think the best way to look at what Congress was doing in light of that context is to consider the fact that Congress went further and enacted C2. The broader lesson Congress took away from Enron is that when you set out in advance to try to enumerate all the various ways that official proceedings can be obstructed, things will slip through the cracks. You can't
Let me
always
just ask you this, was C2 enacted at the same time as C1?
Yes, it was.
And so why couldn't the broadening relate to other ways in which one might prevent a proceeding from accessing information? So one is documents, records, and other objects, but the known unknown, we don't know, could it be intangible, for example, that C2 is sort of getting at when one gets at...
I'm gonna try a silent one. We'll see what happens if I'm just silent on TikTok. Like, I'll still be here. I'm just gonna be silent though. We'll see. We'll see.
So I think the reason why we wouldn't suggest that the context could bear that narrower reading is because of the actual language that Congress used. If it was really just worried about other kinds of record-based, proceeding-based, evidence-based ways of obstructing, then there were easy templates.
We'll see how this goes.
As a residual clause to C1, there was no need to have this entirely separately numbered prohibition, and especially there was no need to use the well-recognized word phrase obstructs, influences, or impedes, which was clearly drawn from these other
Psychonaut says I can't hear you.
So I think we think that it's perfectly consistent.
Read the screen. Alright, I gotta change the
Proceeding to not be a crime. We do want to cover the waterfront of obstructive conduct with the backstop of the corruptly mens rea, the limitation to an official proceeding, and so forth. And that's exactly what the words of the statute say. Thank you.
Thank you, counsel. Rebuttal, Mr. Green?
Justice Sotomayor, a defendant who tips off a grand jury witness or tips off the targets of a search warrant is someone who is certainly attempting to impair the integrity.
What up, Josh? How are you?
And would be covered.
What?
Just as somebody who creates a document and then that document is shown to counsel and counsel withdraws.
It's a keycap. Isn't that cute?
Has in fact created.
I think it's cute.
That has caused an interference with an official proceeding. I heard my friend say twice in response to your questions, Justice Gorsuch and Justice Barrett, that C2 would cover peaceful protest. The government could demonstrate that there was the adequate.
Sup, dude? So just don't tell me what your username is. Leave and then come back on the other username and be like, "Hey, bitches, I'm here." Everybody switch names out. Switch your names out. If you're going to be on YouTube, don't dox yourself. Don't dox yourself.
There is no nexus. Congress has written it out of the statute.
Your printer will be here tomorrow. Fuck yeah.
Came on January 5th.
Now I know who you are.
Did all the kinds of things.
Now I know exactly who you are. Dude, I had my first nozzle clog and I had to do a cold pull. It was relatively easy. So, yeah. Hey, Tenchi, do you have these,
Because the government's allegations are taken as true at the motion to dismiss stage. And I think that's exactly right. And that's why it's not a break at all. Or if it's any kind of break, it's a break on a go-kart. It's a wooden stick. What it means is that people like Mr. Fisher have to sit and go to.
Do you have these, Tenchi?
Seek to win on a Rule 29 motion because the government.
These are tiny little needles, and they help you unclog your 3D printer. So if you have these, and you get the right size one, you can stick it up your printer and clog the and unclog the clog.
There are much lower penalties for significant crimes. I would point the court to 1752, which is civil disobedience in a restricted space, which is what Mr. Fisher is charged with. That's a misdemeanor.
They pop you again? No.
Substantial bodily injury.
Yeah, it's easy though, Josh. It's easy.
A 10-year maximum penalty. The government wants to unleash.
You don't? Really?
Maximum penalty on potential
Really?
peaceful protests. That in and of itself.
That sounds like a good time. Not with a needle, Tenchi.
To chill
Friend.
activities. People are going to worry about.
Not with a needle.
They engage in, even if they're peaceful, because the government.
Yeah, it's really easy, Josh. It's really easy. Real easy. You just gonna need the gloves that come with your printer. I'm fairly certain they give you gloves, but it allows you to. I think that the gloves that you're gonna get, make sure that these are the correct gloves that come with the printer. But I think mine came with heat resistant or heat proof, probably heat resistant gloves. What I ended up doing with mine is I heated it up to 140 degrees. Then I dropped it down to 100 degrees, and when it hit 100 degrees, I shut the machine off, took the front plate off, unclipped the hot end, used my pliers, pulled out the hot end, grabbed the filament, and oh, I'm muted. How did that happen? Oh well. All right, well, we're done with the court. The court's done for today. Court is done, I believe. I don't know what we're gonna do after that, but you know, I love this mic. I love this mic. My only gripe is that if I accidentally, it'll turn on. I'm muted. Read the screen. Jesus, man. You're muted. Read the screen. Read the screen. You're muted. I know. I know. I'm not used to sitting in silence. I don't mind it. I'm just used to having music on. Maybe. Nah, it's all good. We only got 5 folks in there. They're just some stupids. They got some MAGA supporters. Just some stupids. You're muted. Read the fucking screen. Like, I don't know what else you want from me. You're muted. I put it behind me. They should learn how to read, though. They should. They should. You know what we can do, though? You know what we can do? We can have a panel. I'll just stay muted. Do y'all want to do a panel? I'll just stay muted on TikTok. I'll talk shit here on YouTube. I can even pull the panel up on here on YouTube. So, anybody want to do a panel? Anybody? I'll probably restart the TikTok live first. Probably do a full phone wipe. It is quiet. It is quiet. It is quiet. All right, folks. Much love on TikTok. Go follow me on my YouTube account. I was trying something with a silent one where I didn't speak at all. It still didn't fucking matter. TikTok apparently doesn't like me. I don't know. I might be off my mark here, but go follow me on YouTube. So much love. I'm going to be restarting TikTok here. I'll probably go live maybe 12:30. Let's go on 12:30. And go live on around 12:30 on TikTok. So much love. Bye, TikTok. Okay, YouTube. I can play royalty-free music. What is royalty-free music? Royalty-free music. Okay, so this is royalty-free music. Can I have it like... Oh. Okay. So this is royalty-free music, YouTube. I just closed out. My TikTok. What's some good royalty-free music I can play, like, on a loop or something? I don't want to have to, like, keep clicking this shit. I'm so lazy. Alright, more royalty-free music. Just something in the background. Discover unlimited royalty-free music. Sweet. Alright, I'm going to leave this on. I'm going to take a short break. I will be back. And I love y'all.
outside till you get home. Will it do me any good to get you alone? Will it do me any good? You keep running.
30 minutes left. Sweet. Maple, you want to say hey to the people? Here, come here. Come on. Over this way.
You're so reckless, testing our luck, and I know better, but I never stop. But I never stop. Oh, I never stop. You're in my head again. We're sitting on the edge, swinging our feet. Will it do me any good to memorize you? Will it do me any good? We go looking for the same old thing. You got that
Sit here
same
for hours.
old game. You got that same old smile.
Never mind.
We go looking for the same old thing. You got that same old
That's Maple, for those of you that don't know.
felt in a while.
And she's adorbs.
Keep running, calling my name, and I keep going, playing your games. You're so reckless, testing our luck, and I know better, but I never stop.
Ooh.
But I never stop. I never stop. Never stop.
She's so good. She's such a good puppers. Oh, she's such a good puppers. My little one was asking. He was like, "How long do dogs live?" And he was looking at Maple. So we had that conversation about a week ago. I ain't ready, man. I'm never ready. I'm never ready. I feel like we just lost Sophia and Xander. Maple's about to be fucked. Man, she's about to be 5. God. So how can I can I play back to back to back to back to back? Is this really a free, royalty-free music? Yeah, it says royalty-free. No, I'm on Motion Array. Does Spotify have royalty-free? Educate me, I am a boomer. Help me with Spotify. I guess I gotta sign up for Spotify, huh? Yeah, same here. Same here. You know what my favorite one is? My favorite one? Why isn't this shit working? What the fuck? Okay, sign up, I guess? My favorite one is the Hobbits orchestra when they get like famous orchestra to do like big movies like Star Wars or The Hobbit or Disney movies, Pixar movies. Love it. I fucking love it. Yeah, it's free with your plan. I hear you. Oh, I already have an account. Sweet. So sign in. Right? Like, what? Let's see. Please don't play any of these songs. Let's see. Royalty-free dance music? These all royalty-free? Ain't no way. That's not, I'm sorry. Wait a minute. That's not royalty free. Is that royalty free? There's no way that's not royalty free. I'm sorry, YouTube. Wait a damn minute. I don't think that was royalty free. I'm new to this thing, so bear with me. yeah, it's not royalty free. Nope. Mm-mm. How is that the first one that fucking shows up, though? Like, that doesn't make any damn sense. Okay. Okay, free music. It's not bad. It's something. It's just something. All right, folks. Well, the Gen AI is coming soon to Premiere Pro. That's really fucking cool. When is Gen AI coming soon? When is that going to hit? Do we know? Anyone know? Let's find out. What's very high? Let's do a very high energy level. Ooh, this one's called dubstep. All right, I'm shifting gears. Dubstep. Whoa. Can we stop? Play it. Thank you. I like that one. All right, I'm going to sign up for this website. Yeah, I like this one. Okay. I feel like doing 10 things over. Oh, I'm sorry, Tenchi. Staying hectic busy, huh? Doing 5 things at once. Oh, I'm sorry, Frank. You see what I'm printing? Let's switch it over to... There it is. D&D stuff. Very cool. It's a broom holder. When these come out, the whole thing will pop out. And when the broom pushes in, it'll all lock itself back in. And you can pull it out. And it'll just click back and forth. So I'm printing one, seeing how it'll go. It only took an hour. And yeah, I'm selling all my printers except for my A1 Mini. Maybe not all my printers. I'm probably gonna keep one Ender just for I know exactly which one I'm keeping too. Only takes an hour. Just gotta yeah. I don't mind this song either. This isn't super high energy level. I like it though. Fucking pumped with this song. Oh yeah. So Josh, go here instead. Check this out. Check this out. Where the hell is it? Oh my god, I got too much shit open. Okay. Hang on, I gotta close some shit. I got too much stuff right now. I like that song. That was fun. got so much stuff open right now. Okay. Now, I go here to Da, and then here to Did it follow me over? Okay, there it is. All right, Josh. Check this out. So this is what you are going to have full access to. So if you have the A1, say you want this Garfield. What I always recommend people is you go to all printers and find your A1 Mini. And you can do a single color or multicolor. So if you do this one, then you go into Bamboo, open in Bamboo Studio. And then it's loading in right now, but you can't see it because it's... I gotta move it over. And then... we open this. This is monochrome, where it'll come out just whatever filament you have in your printer, or it'll come out 4-color. So once you have this, you go up here to slice plate. $17 hours and 9 minutes. And then once you have everything plugged in right here, it says cost $5.59. So it's going to cost me $5.59 to make this. If you want to go back, you go back up here to prepare, and you can switch. And you're like, okay, well, you know, I don't think I want it that bad. You can just go ahead and do the monochrome, and then you hit slice. Does its thing. 2 hours and 30 minutes. And it costs you 99 cents. So you can print it in whatever filament you want and color it in yourself. But those are some different options. Let me go over here. Excuse you. I'm not a no on this song. I'm kind of digging it. Okay, so 2 hours and 30 minutes, and your Garfield will be printed in monocolor filament. And then 17 hours and 9 minutes for a multicolor one. These are all your different plate sets here. So yeah. Yep. It's the Bamboo proprietary app. So once you go into your Bamboo app, you click up here, top left corner, and you go to online models and track all the way to the right. You click more, and boom, it'll kick you into second. Kicks you into this.
Shut up and sit down.
Featured models, you can go up here and see all the featured models. And you're like, oh, this little Jeep kit card is kind of cool. You go to here to all printers, A1 Mini, and you have different selections you can pick from, different styles, configurations, etc. Then you click your Bamboo Studios and you're good to go. And these are fucking cool. Look at this thing. But sadly, it's too big for ours. So, next month, when the A1 comes out, I'm going to be getting that. And then I'm going to be getting things like this. How freaking cool is that? 3D preview. So this is how it prints. Prints down like that. That's fucking crazy, y'all. Look at what printers can do now, y'all. And if you have an enclosed printer, you can even make these little red strands you see here in the middle. You can make them a clear. Will look more clear. That's fucking cool. That's so cool. Deselect everything. Helldivers 2 helmets. It's already coming out now. Finger tracks. No fucking way. Ho 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 ho! Oh shit. I am gonna be playing with this damn thing myself. Me. One hour and 52 minutes for this thing? That's fucking crazy, man. That's crazy. Yeah. Yep, let's do it. Why is it printing this way? Why isn't it printing the other way? Wouldn't it make much more sense for it to print? Wait a second, y'all. Why is it printing this way? It should be... printing this way. Maybe the flat part's on the ground. That should be faster. Loading regions. You didn't configure it right? Auto orient. What? They did it upside down again? Jesus, take the wheel. What are you fucking doing to me? Okay, fuck it. We'll just send it this way. That doesn't make any fucking sense. Whoever designed this was not an engineer. I said what I said. Okay, we're gonna make this a little interesting. Isn't this cool? Isn't this cool? The cool thing about this too is, let's synchronize. So I have all my, yeah, okay. So the number 1 spool slot is black, number 2 is gold, 3 is red, and then we have a gray and 4. So the cool thing about this is that what we can do here is go into the paintbrush, and if we're like, hey, I need this whole thing filled here, red, it will only make that red. And then if you wanted to make this gold, that's it. It's that easy. And then you just hit print and you're fucking good. It's literally that easy. Isn't that wild? I mean, shit, we can take it a step further. Watch. We'll do it this way. No, I want to... see if I can... Oh, you fucked it up. See, I told you he wasn't a fucking engineer. Engineers never would have let that happen. That's that bullshit. I'm mad. I'm mad. I'm real mad. I'm real mad. How come y'all didn't tell me you could see this? I'm gonna have to do it all over again, aren't I? Jesus Christ. Okay, hang on. Open in Bamboo Studios. None of y'all can see that? I'm mad none of y'all said anything. I just assume that y'all keep tracking with me, but I guess not. Okay, Bamboo. Finger tricks. Alright. Look at this thing. So what doesn't make sense to me is, why would you bridge across the top, right here, when it should be, like this, where it'll just build on the flat surface here, and then build vertically, but when I slice it, it says this. Warning, object is floating. See all those problem areas? It's floating. Look. Whoever made this is not an engineer, and it makes me slightly... It makes my eye twitch. It makes my eye twitch. It's okay. But, what the hell, man? What the hell? Alright, so we're going to orient the object the best way, and it flips it this way, so it's got a bridge across. That's stupid, whatever. Okay, we're going to load in our filament here. Okay, so this is our filament. You click up here, and you can synchronize, resync. That syncs what you have on your printer into your slicing program, which is really nice and convenient. Okay, so on number 1 I have black, number 2 I have gold, number 3 I have red, number 4 I have just a generic gray. So if you go up here to the paint mode, once you click your object, you go up here to your paint mode. These are all different things that you can do. You can just surface paint like this. Everything that you can see right now is gonna be red. But that's just straight on from this perspective. So you'll see here in a second. Okay, right? Looks all red there. But once we turn, you can see not everything is red. Just from that viewpoint. So we get rid of that, Control Z, we can get rid of it. Pretty simple, pretty easy. Alright, if we go in here to fill, we bring it all the way to the right that we can. I want everything to be red. So that entire chunk part just turned red. If I wanted that to be looking a little fancy, we can make it gold. And then if I wanted these little things to be red, I can change them to red as well. And this is actually how I think I'm going to print it out. I think I might print it out this way. I think that looks pretty cool. So if I'm happy with it, you go up here to slice, you hit slice. It does its thing. Yeah. Okay, so it slices okay. It's going to take 8 hours and 3 minutes just because of all the switching is going to take place. Look, we have a little issue here. We got a little bleed through from the red. See, we got a little more down there as well. Interesting. So what we might end up having to do is let's revisit this whole thing, and we're going to make from the top up here, whoops, not red. I want it to be, can we, now we're having some freezing issues. Okay. Ooh, my computer is not liking this one. Oh my god. Take it granted. Okay, let's see. If we slice it, it's going to be solid color. That's the key. We want to make sure it's solid color right now. What about this? All right, yeah, so this is a solid red part now. Okay, cool. So, I want to make this like that. So this is my gripe. This is my gripe with this part. Right? We're gonna make it look really cool, really nice, really neat. Look, it's gonna be every other one, but it won't fucking do it. This person was not an engineer. Engineers would not let this shit happen. Lame. I think when this part is done here, I'm going to try to print this. 8 hours and 4 minutes. See, it's still bleeding through though. See? That's why you have to check on your parts as you do them. Sometimes you'll have some bleed through. Hopefully it will be concealed by the parts. Oh, look. The part's gray on the inside there. So that would be a little bit of a problem. Is this so you can have more than one? Like, you could put them together and have a little tank? I just want to, like, drive it. This one's almost done here. 0 minutes. 98%. Nice. Nice, nice, nice. There it is. We are done, son. Ow. It is very hot. That's cool. So, when you put your broom, it'll just capture it. That's cool. Do I have anything to demo this with? Because why not? Maybe. Hey, look at that. That's in there. That's in there. Sweet. This is gonna help out a lot. Amazing. Digging it, digging it, digging it, digging it. Look at those lines, man. Looks great. Beautiful. Thank you, my little A1. I need to come up with a good name for my A1 printer. What would be a good name for my A1? That's what she said. Giggity goo. Slice. Why is it not showing up? What? Finger treads. What? I don't know why it's not printing and showing up, but whatever. So it's an hour and 54 minutes to print one. So how long would it take to print? No. Why won't it show my damn slicer? Well, I guess I can show you all this. I don't know where to put me. Whoa. Maybe here? Shrink. That'll work. Okay. Let's see what else we have. Yeah, fun translation joke. I like it. Airless ping pong balls. I needed this thing. I needed this thing. Excuse me. Ooh. That'd be cool. I have to make that one. Whew. JB! What up, friend? Welcome, welcome. We're going through some 3D prints. That's so cool. I might just have to do this one. It's all 3D printed. I can't do it. Fuck. Not yet. Hello, hello, hello. We're listening to royalty-free music because it was just quiet. That's so fucking funny. A TIE Fighter desk lamp. How fucking cool is that? That's so cool. Floating can coolers. Ha! You know how I say my 3D printer poops? Well, look, they have a Rick and Morty pooping magnet for your 3D printer. I mean, everybody poops, so. Isn't it cool? Look. You can 3D print shit. Isn't that awesome? What a world we live in. Look at this. A toothpaste transfer tube refiller. Interesting, interesting, interesting. Look, tulip earrings. Those are fucking cute. This is fine. That's great. It's crazy this is a 3D print, y'all. Letter openers. That's cool. Look at those phone stands, man. That looks legit. That's so cool. Look, a sperm bank. That's fun. Courtney! What up, friend? Welcome, welcome. We're just farting around on the 3D printer. I like that horror unicorn. That's cool. I like the Deadpool voodoo. Excuse me. That's cool. Shoe protector. That's cool. Start button cover. Walter White Laboratories. That's fun. That's cool. That's cool. Wall art, monster in the corner. That's cute. Yoink. I don't like this song. Next. What mood? Action? What mood? Action. Let's do some action. That's cool too. Oh. Did have something pop off. So, let's see. What popped off? Oh. No? What popped off? Rubbing alcohol all the time. Okay. I know. Aren't they cool? I think my wife's gonna like them too. But they won't work on my printer. So. God, I don't really want to have to do a fucking... Alright, I'm gonna try this again. could put a brim around it, but it's gonna be such a pain in the ass to take that brim off. I really don't want it. I'm gonna try it again. I can do a raft, but I shouldn't have to do a fucking raft. It should just stick. So hopefully some of my cleaning fixed everything. Alright, y'all. I think I'm going to sign off for the day. So much love. I hope y'all have a fantastic rest of the week. I will be on tomorrow. Probably doing the same thing. Same similar thing. So much love to y'all. I'll see y'all tomorrow. I'll see y'all in the Discord. I might hang out in the Discord chat for a little bit. But